Okay. Everyone, can you see Joan?
Yes, we can.
Yes, we can.
Oh, do you want to be on camera, Joan? Or would you like to move? Well, you need to move farther to the right. Okay.
Personally, I enjoy
this.
What did she say? She enjoys something about you, I think. Oh. All right.
Seeing Joan's face.
Oh, yeah.
I can see now, too.
All right. I've got my notes set up. Sorry, folks.
Yep. I'll do an introduction and then your turn.
So you're going to do an intro, and Daniel, did you get the resources and the slides?
I did, yes.
Okay, great. So the resources should go in the chat. You probably remember that from last time we talked about this before we had to cancel. Thanks.
Yeah.
And
they're all in there.
Great, thanks. I'm going to see if I can make the chat appear.
Karen, is there any way you like the introduction? There's a little bit of feedback.
Sorry?
Can you mute during the introduction?
I certainly can.
All right, everyone. Welcome to the Feminist Lunch Series. We're really happy today to be hosting Karen Pearlston. Karen and I have been trying to make this work for a number of years, and I'm really happy that 2021 is finally the year that we get to have Karen with us with this really important talk called Approaching Lesbian Legal History. Just before we start, I'd like to do a land acknowledgement. We respectfully acknowledge that UNB stands on the unsurrendered and unceded traditional Wolastoqey land. The lands of the Wabanaki people are recognized in a series of peace and friendship treaties to establish an ongoing relationship of peace, friendship, and mutual respect between equal nations. And we encourage all of the participants today to consider how they respect that relationship in their own way. So today we have with us Karen Pearlston. I'm Sophie Lavoie. I'm the organizer of this series, which is sponsored by the UNB Faculty of Arts, the UNB Gender and Women's Studies Program, and the UNB STU University Women's Center. Karen Pearlston has taught at UNB Law since 2002. She's published quite a few articles that you'll see in the chat if you'd like to consult them, that interrogate the history of the law that denied legal personality to married women and the history of family law in Canada. And a number of the articles that she's published are in the chat, and you can definitely look for those. She's also a local activist who's been very active, at least in the last few years, with the movement for reproductive justice here in New Brunswick, with the movement to make the 8420 law get that annulled. And although we haven't actually accomplished that, Karen, you've been doing such great work. We're really thankful for all of your activism on that front and among many other fronts. I think the first time I met you was at a Palestine support meeting for the Fredericton Peace Coalition, which existed when I moved to Fredericton, which that was 13 years ago, Karen, so that dates us a little bit. So as I said, Karen's talk is titled Approaching Lesbian Legal History. She'll be talking for about 30 to 35 minutes, and then we'll have a period of question and answers. We welcome you to keep your questions and comments for that period, and I'm going to turn it over to Karen right now. Welcome, Karen.
Thanks, Sophie. Can everybody hear me okay? Okay, great.
Yes.
Thank you for the wonderful introduction. I'll just add, so I've been teaching at UNB since 2002. And my pronouns are she, her. And also, I'm really excited that so many of my students and former students appear to be attending the meeting. So welcome, everyone. So I called this talk Approaching Lesbian Legal History because I'm trying to actually figure out, I've done some research, which I'm going to summarize for you, but I'm actually trying to figure out some issues around lesbian legal history in particular. And I've been away from this research for a bit because I've been busy with other projects that are more activist or community oriented. I spent most of 2019 working on the Anti-69 project, which was a national effort to try and bring more truth to the federal government's claims that homosexuality had been decriminalized in 1969. And some of my work on lesbian legal history supported our claim that that wasn't true, that there was a partial decriminalization of some things. Anyway, so I've been trying to get back to this research, and I'm really excited to be able to present this project to this group because I'm hoping that I'll get some good input. So at this point, I've published 2 articles on lesbian legal history in what's currently known as Canada, and they're listed in the chat. I've also asked Daniel to put up some other resources in the chat, which are basically articles and film and the film that I refer to during this talk, in case anyone's interested in following up with any of that stuff. So, so what I want to try to do today is first tell you about my findings and then raise some questions about historiography and about sociolegal studies. Oh, sorry, Daniel, is the first slide up? It's the introduction slide. I just got these slides finished and over to Daniel very recently, over the last few minutes, so I'm hoping they're there. And there, so the artist is my partner, Joan, who you can glimpse her arm at the edge of the screen, I think. Anyway, so where was I? So, so I want to tell you about my findings and then raise some questions about historiography and sociolegal studies. So to start out with, the legal histories of women who have sex with women aren't the same as the legal histories of men who have sex with men. The histories of gay men in the English-speaking world is in many ways a legal history because it's been structured around a story of legal oppression by the criminal law in particular. And legal records, when you can get them, are really useful as historical evidence. But the history of lesbianism wasn't structured in the same way, in part because lesbian sex wasn't illegal. And also because women in the past who had sex with women were generally harder to identify and to find for all of the usual reasons that historians of women talk about. For example, they lived less of a public life than men did. And also the pre-20th century world was relatively homosocial, right? Women worked with women, men worked with men. There wasn't the same kind of social mixing of men and women as we have today. But there are also reasons why it's hard to find lesbians in the past that are specific to the sexual lives of women who had sex with women. For example, they weren't illegal, so they don't appear in the legal records in the same way that men did. And of course, questions of identity are fraught. And some of the people who are identified as lesbians in the past may actually have been trans. So, so my research is organized around particular statutes. Can I have the next slide, please? And this slide is a short summary of the statutes and also a bit of an outline of what I'm going to talk about today. So women who had sex with women weren't subject to the legal prohibitions against buggery and gross indecency. So that's point 1 on the slide. And that persisted even after gross indecency, the law against gross indecency was made gender neutral, which happened in 1954. That's point 4 on the slide. And that means that the 1969 criminal code reforms in point 2 on the slide didn't reform the law with regard to sex between women. So, and my argument is also, you see point 3 on the slide, that lesbian sex was regulated for the first time in Canadian law by the Divorce Act 1968. So let me start with a bit more detail about buggery and gross indecency and the 1969 Omnibus Bill. The next slide, please. So buggery, also known as sodomy, or sometimes as the crime against nature, was first criminalized in England in 1533 during the Tudor period. And the crime was never clearly defined, but it always included anal intercourse by a man with a woman or girl, another man or boy, or a beast. So it was something that men did to other beings, and women could only commit sodomy by lying with a beast. That crime was apparently enough to police sex between men in England until 1885, when Parliament passed another law that explicitly applied only to men. And that's the law against gross indecency that you see on the slide. So you see it's directed specifically to any male person. So, like buggery, the conduct that constitutes gross indecency was never clearly defined by a statute, but it outlawed everything sexual that men did with each other besides anal sex, because anal sex was already outlawed. And that continued after 1954, when, as you see at the bottom of the slide, there was a major revision to the criminal code, during which the law against gross indecency was made gender neutral. And that appears to be a bit of a contrast to the United Kingdom, where there was an attempt to make the law of gross indecency gender neutral in 1920, but that was rejected by the House of Lords. So in Canada, in the 1950s, the crime was made gender neutral. But as I'll discuss, it still continued to apply only to gay men, or almost only to gay men. So my point so far is that the main laws against men having sex with men were specific with men and didn't apply to women. And then next slide, please. Then in the 1969 Criminal Law Amendment Act, which is often referred to as the Omnibus Bill, Parliament amended the law by creating an exception to the laws against buggery and gross indecency. So if you look at it, it says those two sections of the code don't apply to any act committed in private between a husband and his wife, or any two persons, either of whom is 21 years or more of age, both of whom consent. So it was no longer a crime to commit gross indecency or buggery if you did the deed in private and you were either a husband and wife or two people over the age of 21. And by the way, the general consent to age of consent for most sexual acts at the time was 14. If there were more than two people present, the act could not be deemed to have been committed in private. So again, these laws didn't apply to sex between women. They did apply to sex between women and men and created an exception. And they also created an exception for anyone. So they created an exception for men who had sex with men. Okay, so that's the Omnibus Bill, buggery, and gross indecency. The year before the Omnibus Bill criminal code reforms, Parliament passed the 1968 Divorce Act. So the Divorce Act 1968 was a major reform. It was the first national divorce legislation, and it made no-fault divorce available for the first time. So before 1968, you could get divorced only by proving a fault ground. And the categories of marital fault had their origin in the canon law and were codified in England in 1857. So fault grounds included committing adultery or cruelty, or committing sodomy, bestiality, or rape, which were known as the unnatural acts or the crimes against nature. In contrast, no-fault divorce means that you don't need to prove that one spouse committed a marital fault. Instead, you can prove marriage breakdown by living separately for a designated period of time. So today, almost everybody gets divorced by living separate and apart for 1 year. This was a hugely important shift, but its importance has, so the shift to no fault was hugely important, but its importance has tended to overshadow the retention of the traditional fault grounds in the 1968 legislation, and especially the addition of a new one, as you see in Clause B, that a spouse since the celebration of the marriage has engaged in a homosexual act. And of course, as you'll notice, it was added to the list of so-called unnatural acts. So my first finding was how and why this addition happened. The bill that eventually became the 1969 Criminal Law Reform Act was first introduced in 1967, which was the same parliamentary session where the divorce bill was first introduced. So it may be that the debates on homosexuality, which Gary Kinsman described as extremely homophobic, influenced discussions of the divorce bill and led some MPs to notice that the grounds for divorce didn't include lesbian sexual conduct. Whatever happened, a Tory MP from Halifax named Robert McLeave suggested during the parliamentary committee study of the bill that possibly we were not exact enough to rescue men from marriages in which the female partner is a practicing lesbian. So McLeave, of course, was right that lesbian sex wasn't included. Gay sex couldn't be adultery because adultery was defined as penis and vagina sex only. And sex between men was thought to already be covered because sodomy was a ground for divorce. So McLeave made his complaint, and the next day, the Justice Minister and soon-to-be Prime Minister Pierre Elliott Trudeau amended the bill to add the homosexual act ground, specifically so that a wife committing a homosexual act would be grounds for divorce. But no one was quite sure what that homosexual act would be because sex between women hadn't been illegal. And judges at divorce trials in the 1970s didn't have any precedents to rely on when deciding whether a wife had engaged in a homosexual act because lesbian sex hadn't ever been illegal. So they had to figure something out because if a spouse petitioned for divorce on the homosexual act ground, then the homosexual act had to be proved or the divorce couldn't be granted. So my second finding is about what constituted the homosexual act between women. And this question was answered in two cases, answered for the purpose of the Divorce Act in two cases. The first was a case from Prince Edward Island from 1972, the M versus M case. And in M, the two women were Mrs. M and Mrs. G. And Mrs. M and Mrs. G each lived with their husbands on Prince Edward Island. Mrs. M and Mrs. G appear to have been very much in love and to have conducted their sexual affair at each other's homes. And the two women eventually left PEI for Ontario, where Mr. M served his wife with divorce papers. Mrs. M stayed in Ontario and didn't appear at the trial. Mrs. G left Ontario and went back to PEI and reconciled with her husband. So Mrs. M didn't appear at the trial. Other people spoke for her. Mr. M said that his wife had described a love like kissing and petting all over the body from head to toe. This is something very different from, penetration with the penis. So the judges and legal scholars were kind of puzzled about how did you figure out what the guilty act was between women. So Mrs. G also testified about her relationship with Mrs. M. And under questioning at the trial, Mrs. G couldn't explain what type of acts were performed between you that would be homosexual acts. She was asked that question. She kept talking about kissing and petting all over the body. But she answered yes when she was asked whether she and Mrs. M were sexually aroused by each other and reached a climax, if you may use that word in these relations. So she said yes. And the judge granted the divorce based on his finding that Mrs. M and Mrs. G engaged in mutual fondling of each other's naked body to such an extent that each woman would reach a sexual climax or orgasm. The judge in the M case put a lot of effort into explaining his decision. He drew extensively on a book written by an American jurist called Sex of the Law, which was published in 1962. He drew on that book, among other things, to describe the usual techniques of the female homosexual. But he failed to identify which of those techniques Mrs. M and Mrs. G used. And that omission left room for the judge in the next case, Gavronsky, in 1974, to offer a far more expansive definition of what constituted a homosexual act between women. So Mrs. Gavronsky admitted that she and another woman had caressed each other's breasts. Oh, can I get the next slide, please? And the judge, and because of that, the judge reasoned that such an act by a male person to a female is unquestionably sexual. It follows that between females, it is a homosexual act where the relationship is, as here, strongly suggestive of a mutual homosexual attraction. So the judge in Gavronsky held that evidence of orgasm was not required for an act to be homosexual, but then added, well, nor do I see any reason to require that there must be proof of vaginal contact. The test must be, was the act homosexual? In some cases, perhaps, a friendly caress of the bosom of one female by another may not be homosexual, but in the present case it was. He also, saying that you don't need to have an orgasm is one thing, but saying that you don't need to have genital contact is another. And I also think he's maybe a bit confused about the difference between a vagina and a vulva, as many people continue to be. Anyway, the non-genital approach in Gavronsky persisted in the subsequent cases, even though it potentially raised difficult legal problems. So that's what we got with the definition of the homosexual act in the family law cases. The homosexual act ground for divorce was repealed in 1985, but the fact of its existence left married women who had sex with other women vulnerable to a high level of scrutiny of not only their sexual, but also their social conduct. And the approach that was established in these cases helped to perpetuate the legal barriers to custody of their children that lesbian mothers in Canada were forced to endure for at least the rest of the 20th century. Okay, so next thing I want to talk about is how I know that gross indecency wasn't applied to lesbians even after it was made gender neutral in 1954. So making gross indecency gender neutral was something quite new, because what it did was it removed any necessary link between gross indecency and male homosexuality. So I started to research cases decided after 1954. And because the law against gross indecency was used against men who had sex with men, I assumed that I would find women having sex with women, but I didn't. Instead, the few cases I found were about women having sex with men, and in each case, the woman was treated as a victim or a witness, and only the male partner was tried for the offense. And I think this happened largely because a gender-neutral gross indecency offense made it possible for a woman to participate in sexual activity that was at the same time consensual and prohibited, and that this new situation was perceived as a threat to heterosexual men. Can I have the next slide, please? So I didn't have to work very hard to piece that bit together, because it was explicitly stated by powerful men in the legal establishment. For example, the excerpt from the Canadian Bar Review that you see on the slide, where the author, Joseph Sedgwick, complained about the uncertain nature of the offense. So he wrote, "I do not know what an act of gross indecency between a man and a woman is, but whatever it may be, it is now an offense. Nothing in this section requires that the act take place in public, and thus what two lovers or man and wife may do in the privacy of their own apartment may turn out to be an offense. To some narrow minds, all acts of sex are grossly indecent." And then he goes on to express fear about the new potential for the criminal law to be used against men. He wrote, "And what a potent weapon of blackmail is thus provided for a woman who is loved possibly too vigorously and later scorned." So I think that's quite an interesting excerpt, and it's also important because it was part of the reasoning in some of the cases where a man and a woman were arrested, and the man was prosecuted and then acquitted for having oral sex with the woman in a car, which was the exact same circumstance in which men were routinely arrested and convicted for having sex with each other. So I'm not going to take time to go through the cases with you in detail today. They're written up in my chapter in No Place for the State. Drop me an email if you're interested and you can't get a hold of a copy. But I just want to summarize how the judges distinguish between cases involving two men and cases involving a man and a woman in this jurisprudence. So where there was a man and a woman, the act of fellatio or cunnilingus was understood to be a normal and natural kind of foreplay. And it was also understood to be quasi-marital. And the couple in the earliest case I found in 1957 were described as very much in love and planning to marry. The judge in that case cited this passage from the Sedgwick article and then referred to the danger inherent in making consensual sex acts between men and women illegal. These considerations were held to distinguish the time, place, and circumstances of oral sex in a car between a man and a woman from oral sex in a car between two men. And when the cases I looked at that involved two men from the same period, the judge held that where there is sexual conduct between men, the indecency depends upon the nature of the act and not upon the circumstances under which it is performed. So this issue was finally resolved in 1968 by Brian Dixon, who was then Chief Justice of Manitoba, but would soon be appointed to the Supreme Court, where he was Chief Justice during the period where the charter jurisprudence around equality was first developed. So this was not, so remember the case I'm about to talk about was in 1968, just a year before the Omnibus Bill was passed. So in this case, the police peered through a window. Oh, next slide, please. The police peered through a window and down a hallway and into a kitchen where they saw a woman giving fellatio to her common law husband. So they arrested them. Justice Dixon acquitted and said, among other things, the words that you see on the slide, that Parliament never intended to attach criminal sanctions to sexual acts done in private by consenting adults of different sex. Mr. Sedgwick was misled in supposing that Parliament ever intended by the new section 149 to intrude into the area of the intimacies which take place in private between consenting spouses or lovers, and it would require words much plainer than appear in section 149 to persuade me that Parliament suddenly decided to enter the portals of the home and to require courts to sit in judgment upon what passes in private between consenting adult spouses. So clearly in this commentary, the possibility that women might commit an act of gross indecency with each other wasn't under consideration. Justice Dixon's purpose was to keep the state out of the bedrooms of engaged to be married or married heterosexual citizens. And this deference to privacy in the heterosexual context was mirrored in the 1969 exception to gross indecency, where it was expanded to cover all consenting adults, but still had little to do with lesbianism. Okay, so that's the report on the findings part of my talk. As I promised in the abstract that I would also raise some sociolegal and historiographic questions about lesbianism, law, and legal history. So I'm going to do that very briefly, and I'm not even going to be able to raise all of them because there are quite a few. But I want to go through them because I'd love to get your input on this. So first, and obviously, the legal histories of lesbians and gay men cannot be equated. Second, most lesbian histories of the mid and later 20th century look at the development of lesbian subjectivity through the building of lesbian community. In contrast, the legal cases I've found involved women who were forced into visibility by the law's need to ascertain whether they had committed a lesbian act. So some of the wives in the cases may have identified as lesbian, but others didn't, or they didn't want to leave their marriages. Some of them probably had very little in common with the lesbian feminists and radical dykes who built lesbian communities in the 1970s and 1980s. So this legal history, and especially the family law part of it, gives us a glimpse of same-sex sexual desire and relationship practices outside of lesbian community. So there have been books and articles about lesbian bar culture for some time. Boots of Leather, Slippers of Gold was published decades ago now. Books about upper and upper middle class lesbians, and books about the development of lesbian nations and communities, like Becky Ross's book, The House That Jill Built. But there hasn't been much about married lesbians until recently with the publication of the book on the next slide, please. So I bought this book immediately when it came out. I'd read articles by this historian, Lauren J. Gutterman. I bought it immediately, but it's been the COVID year and I haven't had time to read it yet, but I'm so excited about it. I just wanted to show it to everyone because I think it's going to open up a lot of space for different kinds of research. So when it came to formal law that specifically addressed sex between women, then my research shows that male homosexuality was viewed as a public problem. But if lesbianism was a problem for the law at all, it was a problem for the family. Now, of course, that's not a full picture. I've been talking about the law's treatment of lesbians as such, as the clear and named lesbian identity or lesbian sexual practice. Another part of the story is about lesbians who were affected by the parts of the law that weren't directly aimed at lesbians or lesbian sex, but that affected lesbians because it affected the kinds of lesbians who didn't live in families or under male protection, or who were too rebellious against their families. So, for example, medieval and early modern single women were policed by poor laws, by vagrancy laws, and by local laws that regulated where and how unmarried women could reside or make their living. Vagrancy laws, anti-sex work laws, and liquor licensing laws, which are all about public conduct, were still used against lesbians in the 20th century. Lesbians were also locked up in psychiatric hospitals, imprisoned in training schools or reformatories as incorrigible, purged from the military and perhaps disproportionately affected by laws against sex work. Throughout the late 1990s, lesbian mothers, or through to the late 1990s, lesbian mothers often had to deny or hide their lesbianism in order to retain custody of their children. And if you've seen, next slide, please. If you've seen the movie Forbidden Love, you'll have some understanding of the social and legal conditions for lesbians in mid-20th century Canada. If you haven't seen it, you really should. It's entertaining and it's fabulous, and it screens for free on the National Film Board website. Okay, so to make a separate point here, with regard to lesbians and gross indecency, so far I've told you that women weren't charged with gross indecency, lesbians weren't charged with gross indecency, but my findings are only partial. And they're only partial because they're based on reported cases, and reported cases are legal cases that are selected, legal judgments that are selected for publication in the law reports. So reported cases are important because they provide the precedents that lawyers and judges use to make legal arguments and decisions. But what's reflected in the cases that are selected for reporting isn't necessarily the same thing as what's happening in the much larger group of cases that are not reported. And they certainly don't represent what the police actually do. Far from it, as we're all aware. Nor do reported cases represent what people think the law is or how the police may represent it to them. And so there is evidence from social historians that gross indecency was occasionally among the criminal charges that police threatened or even arrested certain lesbians for in Canada in the 1960s. You'll find this in the work of Elise Chenier, who also articulates an important class dimension by differentiating between lesbians who called themselves downtowners to distinguish themselves from what they called uptowners. And uptowners were women who lived outside the downtown core, worked at pink collar or white collar jobs, and were careful to separate their gay lives from their familial and working lives. In contrast, downtowners occupied public spaces on the streets or in bars and restaurants and often supported themselves through criminalized activities like sex work or petty theft. Throughout the 1950s, Chenier argues, police in Toronto did not attack lesbians because they were queer, but for other reasons connected with police concerns about street-based sex work and also interracial relationships, because the public spaces that were occupied by queer women were the same spaces that were occupied by interracial couples and by sex workers. In the 1960s, however, things started to change with the appointment of a new police chief in Toronto who aimed to rid the city of prostitution, homosexuals, and drugs. And that was the period when police violence against lesbians who were downtowners were escalated. It was the era when the cops would pick up lesbians and take them to Cherry Beach, which was then an isolated stretch of waterfront. And at Cherry Beach, the cops would take lesbians and sex workers to beat them up or rape them. Now, Chenier also says that where women found having sex together in the 1950s would have been charged with vagrancy, in the 1960s, they might be charged with gross indecency. So the class piece is very important to keep in mind, and so are the changes through time. So Chenier's account and her insights can help to enrich the ways that I can interpret my findings. My findings are focused on the formal law as it's found in the statutes and reported cases. The issues of identity, of class, of changes through time, and of the partial nature of knowledge are all well recognized by lesbian historians. But there's still almost no specifically lesbian legal history. Most of that which exists is about the period between the 1970s and the advent of same-sex marriage, which is supposed to be both triumph and culmination. And I don't think that approach is adequate. We need to avoid relying on stories and assumptions about how the law operated. We need to grapple with the legal framework and doctrine in order to complicate the picture, fill in the details, and portray the flexibility and adaptability of the law. Because one thing that needs to be grasped by both historians and activists is that law is not a one-way thing. Its deep structures have proven to contain a remarkable ability to adapt to challenges without any changes at all in the relations of ruling. So in conclusion, I think three things are clear, at least with regard to a specifically Anglo-Canadian legal history. First, much of lesbian existence has happened within the framework of the opposite sex family, which is where women who aren't in the public world are generally situated. Second, the history of women who had sex with women is also bound up with the history of single women, especially with the not respectable, unruly women who are unable to live within the family and who are punished by law for that and not directly for their sexuality. And third, by the 20th century, something was emerging that could be understood as a specifically lesbian identity, but even for the 20th century, there's almost no lesbian legal history that I know of. In fact, the only article I know that treats lesbian legal history specifically is the one by Ruth Ann Robson that was published in 1990. Anyway, I'm sorry if I've gone over time. I think we can take the slides down. Thanks, Daniel, and start discussion if there is any to be had.
Great. Thank you, Karen. All right, I'm going to put the floor up for questions. If you have a question, you can raise your hand or you can just speak up. I'm just looking around to see if there's any lights. That was fascinating. I love the some of the language. I do narrative analysis, so I love some of the language in those cases that you mentioned, both the PEI case and the Gavronsky case. They're really hilarious. Any questions for Karen? Linda, go ahead. You have to unmute yourself, Linda.
Hi, Karen. Nice to see you. It's Linda. I guess my question would be, you mentioned racialized women at the end. Are there other aspects of racialized women's experiences with the law that would make it unique? I would expect so, in terms of the treatment of women who were seen as from, you know, a racialized underclass kind of situation. And would there be anything especially legal? Maybe it's not legal, but maybe it's practice in terms of how those women were treated by the law.
I say yes, but I feel like I have not delved into this question as much as I'd like to. But something I didn't get a chance to talk about was Connie Backhouse's chapter in her book on the history of sexual assault in Canada, on the very first lesbian trial for an indecent act. And so it's a really interesting article, and in it she talks about two women who were lesbians who lived together who moved to the north, and then one of them had an affair with another woman and was eventually charged not with gross indecency but with indecent assault. And so that's it's Connie's usual very well written, very well detailed and analyzed work. And then right at the end of the article, she says that she had managed to track down the accused woman's lawyer and interview him, and that he said at the end of one of the interviews, you know, I don't think all of this would have happened to her if she hadn't been Black. So there's something about the invisibility of race in the reported law in Canada. And Connie Backhouse was a pioneer in exploring that as well in her book on race and the law. So I think that's happening. I've also seen that a number of the cases that come up as earlier precedent were involved racialized people. So Asian men who were convicted of sodomy, both in Halifax, I think in the 18th century, and out west in the 19th century. And in the cases that in the paper that I wrote, the chapter in the Omnibus Bill book about gross indecency, I actually traced this because there's a discussion of what gross indecency is and what time, place, and circumstance means and what makes an act indecent or not. And that traces back to the Louis Chong case, which was another notably racist case that where a judge said that a Chinese man was liable for indecent assault, not just for assault. And it had, the analysis had to do with the fact that a Chinese man accosting a white woman in those circumstances could be read as indecent. So I think the answer is it's all through it, but it's hard to pin down.
Thanks.
There's a question from Lizette. Go ahead, Lizette.
Hello. Yes, and I would like to know how we see lesbians today in the legal act. How is today?
Do you mean is lesbian sex criminalized or illegal in any way today?
How is seeing lesbians today, based in the legal act?
Well, there's no law against lesbians, and lesbians have formal legal equality, right? So the Charter of Rights, the Supreme Court said some time ago that sexual orientation is an analogous ground under the equality provisions of the Charter of Rights. So that means that lesbians and gay and bi people have equality rights. So that's what the formal law is, but of course we know there's still a lot of oppression. I don't know if that answers.
Yeah.
Other questions, comments on Karen's presentation? I was wondering, sorry, Karen. There's a little bit of an echo, so I'm just going to mute you here if I can. I was wondering if that difference between the downtowners and the uptowners, I'm assuming that was just in large urban centers, or is that just in Toronto?
Cheney's work, that research focused on Toronto, but I think that the general distinction between downtowners and uptowners is probably more general, but the specific pattern and timing of the change in the police approach might have been particular to Toronto.
I guess because I was wondering if there was a correlation between the rise in the number of women in the workforce and the kind of increased policing of those women who lived outside of the home or it's outside of the family unit that you distinguished. Hold on, I'm going to unmute you. Oh, you have to unmute yourself, sorry.
Sorry, Sophie, I think that's, I don't think I know the answer to that question. Like, I've never thought about it in terms of the rise of the number of women in the workforce. I've thought through these issues more in terms of the literature around lesbian history and the development of lesbian community and how the work I was doing on the Divorce Act didn't quite fit into that. So, I mean, the rise of the number of women in the workforce is a huge social change. So, but beyond that, I can't say.
There's a question from Christine. Go ahead, Christine.
Hi, Karen. It's Christine. I'm tuning in from the West Coast. Excited to have heard you. I just wanted to say thanks for that comment or that argument about lesbian community being kind of the focus versus sort of individuality being the focus of the law. I think that's a really interesting distinction. I'm about to write a historiography for my MA, as you probably know. So that's going to be something I think I'm going to think about as I aim to write that. So that's really interesting. Just wanted to say thanks.
Christine, I'm so glad you're here and we got to talk.
Yes, we do. Absolutely.
Any other questions, comments? All right, it looks like you've left everybody with a lot to think about, Karen. So I'm just going to announce that on next week on Wednesday at the same time at 12 p.m., we are having a talk by a new faculty member in the Department of History called Angela Tozer. And her talk is going to be titled Gender, Race, and Settler Colonialism in the Financialization of the Canadian State, Credit, and Public Debt from 1820 to 1880. And so we'll look forward to seeing you then. I want to thank Karen, of course, for her amazing talk, and Daniel Grant for his support, technical support for the talk. And I also want to thank Joan for her amazing drawings that illustrated Karen's talk. It's like we're having two presenters instead of one, so we're very happy about that. Thank you very much on behalf of everyone, and I hope to see everybody next week. Take care.
Thanks, Sophie. Thanks, everybody.
I have one question. Can I have access to the recording later?